How are we doing?
Yes, Mr. Commissioner, again, it's Tim Dixon for the Stalo Tribal Council, and I neglected to say before, but with me is Nicole Chavez. I want to turn now to co-management and ask a few questions on that topic. And the objective of managing collaboratively has a number of sources, I believe, but one of them is Strategy 4 of the Wild Salmon Policy. Is that correct, Ms. Farlinger?
Yes.
And Ms. Gertner, before me, raised the roadmap process with you. And I just want to understand clearly, is DFO committed to supporting and engaging in the roadmap process, Ms. Farlinger?
I think that DFO has been both funding and very much a participant in the development of the roadmap process, and I think that's some indication of our support of it. I think we will need to know where the roadmap process will go in the future, and we'll have to at the same time assess how we participate and how we support it.
One of the issues that we heard about with respect to the roadmap process is that First Nations are unsure of the department's commitment to implementing co-management, and I think part of that uncertainty that I heard is what the department understands co-management to mean. Because sometimes the term co-management is used in relation to co-management with First Nations, and sometimes I hear it used in relation to co-management with all stakeholders. And so I want to get the department's perspective on this point clear if I can. In light of traditional Aboriginal knowledge, in light of First Nations' unique relationship with the fish, does the department agree that co-management with First Nations means something deeper and more intensive than co-management with other stakeholders?
I think that I would just go back again to the approach that the department takes to working with First Nations and the principles that guide that, which have to do with the fiduciary the fiduciary nature of the relationship, and the fact that we are trying to operate with First Nations in accordance with court decisions and legal guidance. That is, by its nature, a different relationship than one we have with other stakeholders. I wouldn't say that co-management, in our view, is limited to co-management with First Nations. It certainly includes all those with an interest in fish and fishery. I think that as it pertains to co-management, the work that is going on through the forum and the roadmap work is very much focused on, in some way, defining what co-management means in this context.
And my point was not to ask Ms. Farlinger whether co-management is only co-management with First Nations or whether it's co-management with all, but that to ask whether the department agrees that co-management with First Nations is going to be a more robust form of co-management than with commercial and recreational fishers.
It would be difficult to be definitive about it, except in the context I just previously said, that we have a different kind of relationship with First Nations, and that whatever we work together on and develop will have to reflect the principles I just referred to. And if by that it means it is more robust, that may well be the outcome of that.
And this uncertainty about what co-management means is, again, a factor that I heard that poses a challenge to First Nations really getting involved in the roadmap process. And what I heard was that a strong demonstration by Ottawa of their commitment to robust co-management with First Nations could galvanize that process, bring First Nations to the table. Deputy Minister, Ms. Gertner was raising the issue of an MOU with, this morning with, I believe, the First Nations Fisheries Council. Is an MOU on co-management within the roadmap process a step that you will recommend be actively explored by DFO?
It wouldn't be up to me to make that kind of recommendation. That would be the kind of recommendation that would come to me after the field work had been done, and then we would deliberate it.
And if that recommendation did come to you, you would take it forward and recommend it to the minister, would you?
There are quite a few ifs in those statements. It's very hard to answer in the general and hypothetical questions. It would depend entirely on the content. It would depend entirely on the desired endpoint.
I want to...
Could I just
Certainly.
add something? I think the fact that among the huge suite of priorities we have, the fact that here in the region of the funding we have, that we have chosen to invest it in building this process, in this instance with the Fraser River, the First Nations concerned with the Fraser River, and that we have a fairly ambitious schedule and timeline around that, and commitment of our own staff is an indication of the fact that we believe this is an important avenue to explore. And once we have done that, as the deputy says, then we'll be in a position to advise how to move forward on it.
Thank you, Ms. Farlinger. I want to move to monitoring, because I think that everyone would agree here that good monitoring programs are essential, and indeed strategy 1 of the wild salmon policy speaks to monitoring, and it calls for local partnerships with First Nations and other groups. That's correct, isn't it, Ms. Farlinger?
Yes, there are discussions of that in the wild salmon policy in terms of how to move forward.
The Commissioner has heard about the work that the Fraser Valley Aboriginal Fisheries Secretariat does on monitoring the fishery in the Lower Fraser, and in recent years expanding into joint monitoring with recreational fishers. And Colin Masson testified that he sees opportunities to expand the work of the Secretariat. Ms. Farlinger, do you agree? Is this work the kind of shared stewardship activity that the department would like to see expanded?
I think under the circumstances that you described, that the relationships that have developed in the lower Fraser Valley, in this instance between the recreational fishery and the First Nations communities, is one of that is only a benefit to catch monitoring. And certainly where those kinds of relationships and projects can move forward, we would be supporting them.
And another program in a similar vein was the Aboriginal Guardians program. And we heard that the Lower Fraser had 18 Aboriginal Guardians at one point, but then that program was terminated. And I suggested that this is again the kind of shared stewardship program that the department should be pursuing. Carl English commended the program. Both Mr. Nelson and Mr. Coltish called for the program to be restored. Ms. Farlinger, do you agree that the program should be restored?
I think that the opportunity to proceed with a Guardian program still exists under the FS program. It's really a question of the priorities of the communities, and DFO. DFO is certainly supportive of moving forward with that program where both communities, where the communities want to move in that direction.
Mr. Bevan, you've spoken over the past several days about the need for CMP to work in a collaborative and integrated way within the department. That's fair to say?
Yes, I have.
And we've heard in this inquiry that CMP used to be part of DFO's matrix management model, and fisheries officers used to report to area directors and be integrated into the department in that way, but now there's a line reporting relationship, and all fisheries officers in the province report to Mr. Nelson. Do you agree that line reporting has impeded the type of integration and collaboration you're calling for from CMP?
It's not necessarily a cause of line reporting. I think that what we need is, and this was an issue that was raised at the time we moved to a line. Line provides flexibility on distribution and utilization of resources. So particularly in a region where you have salmon arriving from the north and moving into the south, and seasons, etc., that may differ, you have an opportunity to look at your priorities and to move your resources accordingly. It also is expected that the management of CMP will work within the context of the regional organization. And that's an expectation right across the country. We want CMP, resource managers, and the people developing the fish plans and monitoring to work together. Just because one's line and the other's at the area level doesn't mean that that can't be achieved. It takes energy and it takes a focus, and I think that's what we need to see more of.
You'll agree that there have been some deficiencies and challenges in that integration between CMP and the area.
Well, I'd have to turn to the Regional Director General relevant to this area. We've had some good success in some locations and challenges in others, and that gets down to the relationships that exist between the people and the fact that they need to work collaboratively because they can't get along with, they can't do it on their own. The resource managers can't make good fish plans happen and be implemented, and CMP can't work on its own if they want to have a suite of measures presented to them to enforce that are practical for enforcement. So it's something that has to be constantly focused on, and you get times when it's working better or locations when it's working better than others, and when it's not working, you really need to focus on rebuilding those relationships.
Mr. Bevan, because I want to touch on the ban of the sale of FSC fish. We heard from many witnesses in the inquiry that if an FSC fish was caught during an FSC opening and is included within a band's allocation, the sale of that fish does not pose any threat to conservation. It doesn't pose a conservation concern. Mr. Nelson, Mr. Coltish agreed with this, so did Mr. Huber, so did Mr. Rosenberger and Carl English. Mr. Bevan, do you also agree?
Well, clearly a dead fish is a dead fish.
Right.
If as long as the number of fish extracted from the system are within the limits, then it doesn't pose a conservation concern. The real concern you have, though, with FSC fish is the increased increased need. If you're taking the FSC and diverting it to sales, you may be seeing a situation where there's an increased desire to catch more fish to make up for that. And that's the concern that we would have.
The real issue is making sure that the harvest stays within allocations. Isn't that right?
That's the focus on conservation, but that could become more difficult if more fish that is destined for FSC use is moved into sales and creates a further demand for additional fish. It may get harder to keep the limits or keep within the limits and have the rules respected relevant to the total catch.
We've heard, Mr. Bevan, that the enforcement against the ban on FSC fish creates enormous antagonism between the department and First Nations. And that, from the department's perspective, it's very difficult to enforce. It uses up a great deal of resources. Do you agree that it raises those two challenges?
I would agree that it is challenging to enforce, but because it has the highest priority after conservation, it is something that has to be treated differently than economic opportunity fisheries.
We've heard, Mr. Bevan, just last point on this, from some witnesses that First Nations could receive a straight allocation of fish without a restriction as to the use of that fish. And obviously that allocation would have to be negotiated. Obviously we're not at that stage yet. But would you agree that it's a possible arrangement that could be explored in the future?
That's a very difficult arrangement to contemplate, given the priority that FSC fish has over economic opportunity. So if all the fishing was done under the same priority, then that's a realistic model. But where you have a Supreme Court decision that notes that after conservation, FSC fish has the highest priority, there's a need to keep that fish separate from economic opportunities, which would have the same relative priority as all other economic users.
Indeed, the issue of priority would be one that would have to be worked out within that scheme.
The mix creates an issue. That's just the reality of the situation if you have priorities that are different for different users.
I'd just like to add that, and I made reference to this earlier in a different context, that one of the basic tenets of fishery management is looking at fishing power and incentive to fish, and that really dictates the framework of management of the fishery. And where there is, and I used the term earlier, a natural limit, there is a very different incentive to fish than where there is economic benefit from fishing. And that is one of the basic reasons that economic fisheries are managed in a different way than those fisheries with what I'm calling at this moment is a natural limit. We see that whether it's in the Aboriginal fishery where we have the priority on FSC, and we see it across other fisheries, for example, in the differentiating the recreational fishery from the commercial fishery. Why? And this is covered in some detail in terms of the catch monitoring strategy, that it really is the nature of the fishery and the incentives that drive it that make management requirements, catch reporting requirements, and the whole management framework of the fishery different. And that's fundamentally, rather than Mr. Bevan's discussion about policy issues and legal issues, that is a fundamental of fisheries management.
I don't have much time left. I want to touch on two more points. The first of them is share-based fisheries. We've heard from the panel, I think, some interest in considering share-based fisheries for salmon. And I want to ask you about this because my clients, and I think a number of other First Nations, are opposed to share-based fisheries for two reasons as I hear them. First, they're concerned about the priority to fish. They're concerned that that priority would not be accommodated as well within a share-based regime. And second, they seek a greater share of the fishery, and they worry that a share-based fishery would create property rights that would make it more difficult to achieve that objective. Ms. Farlinger, have you heard concerns of that kind?
Certainly in a variety of discussions over the years, I have heard those kinds of concerns from some First Nations, and I would say that it is in the design of the share-based fishery that those kinds of matters need to be seriously considered.
Yes, with deep consultation with First Nations. Is that so, Ms. Farlinger?
We do consult with First Nations on both policy changes and of course specifics. So it would be our normal practice to consult with First Nations.
Deputy Minister, I think I have time just for one more question. When the topic of co-management comes up, we always hear from DFO that the Minister has the ultimate authority to manage the fish, that he cannot fetter his authority. Indeed, you raised this point this morning. During this panel, however, the Commission and the participants have heard of the serious budget cuts the Department is facing. I expect all of us found that to be quite depressing, because it appears the Department simply cannot afford to take certain concrete actions, such as defining benchmarks for CUs. We've heard a number of times from the panel that the Department is implementing the spirit of the wild salmon policy, but it can't afford to perform many of the actual strategies within the wild salmon policy. And my question to Deputy Minister is simply this: isn't it true that the Department just doesn't have enough money to implement the wild salmon policy, and that the Minister needs more money to fulfill his mandate to manage the fishery?
Thank you for the question. I think I've said many times that I think we are adequately funded to do our work. I don't want to sound naive or to sound as though I have rose-colored glasses on and to say that more money wouldn't be helpful. Obviously, more money can be helpful, but as I've said many times, I think given the resources that we have, the implementation is moving to the best of our ability. So I think I would not say that the minister is not in a position to fulfill his duties with the resources that we have.
Benjamin Ralston for Health Tribal Council, and with me today are my co-counsel Lisa Fong and Ming Song. To begin with, my questions will be for Ms. Dansereau. Mr. Lund, could you please bring up Health Tribal Council's document number 71? Okay, Ms. Dansereau, if you're ready. Are you aware that during the course of the Commission, an application was made for the disclosure of various documents related to the coastwide framework over which Canada has claimed privilege?
We've claimed privilege over a lot of documents. We've listed them. That's normal practice. Some of those are within the ruling that you made, and I said earlier September 12th. I had my dates mixed up. The ruling we're talking about is September 20th. My friend is now wanting to proceed into our list of privileged documents, and that's an area that I think is no-go.
It's not that we want to proceed into this list of documents. We're simply taking the position that we'd like to enter it as an exhibit in these proceedings.
Well, I object. It's completely nonsensical to enter a list of documents as an exhibit.
Are you finished with the objection? So he can respond.
Well,
Sorry, go ahead.
in his response, I wonder if he might offer to the Commissioner what possible relevance the Commissioner might make of this list were it to be entered.
All right. The terms of reference for this inquiry, as far as we understand them, require the Commissioner to consider the policies and practices of DFO with respect to the Fraser River sockeye salmon fishery and to develop recommendations for improving the future sustainability of the Fraser River sockeye salmon fishery, such as changes to DFO policies, practices, and procedures related to the management of this fishery. We have made an application for the disclosure of the documents contained in this list, and their relevance to this Commission was not disputed during that application. We know from the documents and information disclosed on the coastwide framework documents to date, such as the Aboriginal Fisheries Framework, the list of documents here, and witness testimony, that the coastwide framework is made up of a suite of Aboriginal fisheries policies. This list of documents in our submission is not simply procedural. The list of documents contains the names and types of documents that have been produced, their dates, their authors, and their recipients, as well as the overall quantity of documents over which privilege has been claimed. We submit that it's relevant that the information has not been put before the Commissioner. The Commissioner's recommendations must be understood as not having had access to these documents. Likewise, participants' closing submissions and recommendations must be understood as not having had access to these documents. It is particularly important to First Nations, such as our clients, to have this clarity, as the recommendations do not end here. DFO and First Nations will continue to have an ongoing relationship with respect to the management of the Fraser River sockeye salmon beyond this Commission. And while we take the position that this Commission does not constitute consultation, we recognize that this ongoing relationship will be informed by positions taken in these proceedings, making it all the more critical that we have clarity as to what our recommendations are based on and what they're not based on. Finally, we submit that there would be no prejudice to Canada in having this document made an exhibit, as no privilege has been claimed over the document or its contents. The weight to be afforded to this document is in the Commissioner's hands, and any concern that Canada has with its relevance and probative value can be addressed in their closing submissions. Those are my submissions on this document.
With respect, Mr. Commissioner, it's not sufficient just to say there's no prejudice. There has to be some probity to the document. What we have listed here is akin to what was a Part 3 and now I think a Part 4 listing, list of documents in civil litigation. It's produced that somebody can take issue with the documents should the need arise, and I understood that to be the purpose of this list. My friend suggested that these documents were not placed before the Commission, and I think in parts attributed that to some intention on the part of either Canada or the Department of Fisheries and Oceans. There was an application made for these documents, an assertion of privilege, legal privilege was made, and that has been ruled upon. In my submission, for this document to be marked, my friend would have to convince you that there's some probity to the list. It's in and of itself. Beyond that which related to the application that was made, but which relates to you carrying out your mandate as articulated in your terms of reference.
I don't think I have anything more that I need to add. Mr. McGowan said what I would. It's unheard of to put a list of documents of council in as an exhibit.
Thank you very much, Mr. Ralston, for your submissions. At this time, the document will not be marked.
Thank you. Okay, Mr. Lund, could you please bring up Heltsick Tribal Council's document number 83? Okay. Ms. Dunsborough, this is a letter from Council for Canada, Mitch Taylor, to Commission Counsel Brian Wallace. Mr. Lund, could you please turn to the second page of this PDF, the letter's enclosure? Its enclosure is a letter from the Clerk of the Privy Council and Secretary to the Cabinet, Mr. Wayne Wooters, addressed to the Commissioner. Do you recognize this document?
This is a excuse me, this is a document we saw earlier. Then yes, if you could go to the last paragraph, I can confirm that. Yes.
Could we have this document entered as an exhibit, please?
Exhibit 1966.
Just before it's entered, I wonder if my friend could articulate for what purpose the letter of a clerk of the Privy Council is being entered as an exhibit. It is on the record. The fact of it's on the record, it's listed on the website and is available publicly along with the ruling. But in terms of you fulfilling your mandate, I'd ask him to articulate the use that it might be put to by you, Mr. Commissioner, in fulfilling that mandate.
I might just, and then I'll let my friend speak, say that as I understand it, and so what I'm now saying is based on I understand it, Mr. McGowan or Mr. Wallace may confirm it, when this commission has ended, the rulings of Mr. Commissioner, and this document appears in the same part of the website as the rulings, those rulings, and including this document, would be maintained, if I could put it that way, as a record of this Commission of Inquiry, and it will exist for everyone, and people can use it as they see they need to. If that's the case, while I don't have a position one way or the other on making it an exhibit, if this is part of the rulings part of the web that will be saved, there's no need to mark it.
In our submission, if we can rely on this document as it's currently proposed on the website and in conjunction with your ruling for our closing submissions, I think we would be satisfied with that. Our simple purpose in entering it as an exhibit is to understand the closure on our document application.
Yeah, thank you again, Mr. Ralston. I don't see any reason why you wouldn't be able to rely on it for final submissions.
Okay, thank you. I'm going to stay with you, Ms. Dunsborough. I hope that's okay. Do you know Ms. Sarah Murdoch, the Acting Regional Director of DFO's Treaty and Aboriginal Policy Directorate?
I'm sorry, I may have met her, but I don't work with her on a regular basis, so Ms. Farlinger can speak to this.
Okay, Ms. Farlinger, are you familiar with Ms. Murdoch?
Yes, I am.
Okay. Are you aware that Ms. Murdoch swore an affidavit with respect to the reasons underlying Canada's privilege claims over the Coast-Wide Framework documents and Canada's opposition to their disclosure?
I'm not sure that I am.
Okay, that's fine. I'm going to put to you some of the propositions made in Ms. Murdoch's affidavit to see whether you agree or disagree with these statements. First of all, Ms. Murdoch states that Canada must maintain privilege over documents and communications created for treaty negotiation purposes if those negotiations are to be successful. Would you agree with this proposition?
I object. We're now embarking upon an area of questioning that my friend has already said is material put before you, Mr. Commissioner, on a motion. You were asked to rule on all of this. You considered all of this, and you ruled on it. This has been dealt with. Firstly, it wouldn't be of any help to you, Mr. Commissioner, in fulfilling your mandate to now, after you've had this evidence, considered everything and ruled on it, to hear what Ms. Farlinger or any of the other witnesses have to say about it. And secondly, I don't know what the witnesses would say, but if they say something different, it puts the inquiry in a very difficult position because it would be information different from what you had when you made the ruling, which comes back to, once a ruling is made, those matters are dealt with, and they're not to be revisited for any number of reasons, including the kind of scenario that I just outlined.
I wonder if a sensible way to proceed, perhaps of assistance to Mr. Ralston, to the extent there may be propositions that are relevant to your mandate, I think it's unobjectionable for him to put them to these witnesses and ask them to adopt them without referencing the source of them of his question. And if he's content to proceed in that way, it may well solve the problem.
I'm definitely content to proceed in that way. We have no interest in relitigating the application. I simply want to draw forward evidence on DFO's perspectives on the disclosure of this information. And in our submission, DFO's perspectives as to what information should be shared with First Nations and what information should not, both in treaty negotiations and the negotiations of AFS agreements, goes to their perspectives or what they would consider their limitations when looking to make recommendations on a co-management framework or co-management structure. And in that respect, we think that it's very much relevant to the terms of the Commission.
Could you rephrase your question then and
Okay.
see if it's appropriate?
Okay. So, again, Ms. Farlinger, would you agree that Canada must maintain privilege over documents and communications created for treaty negotiation purposes if those negotiations are to be successful?
I'm certainly not an expert in the matter of privilege. I do, as part of my job, implement a mandate which is provided to me by the government, and really have no view on privilege or not with respect to those. It's merely a matter of following instructions in the mandate.
Now, again, would you agree that disclosure or non-disclosure of information relating to current treaty negotiation approaches and strategies, as well as possible shifts in these approaches and strategies, would disadvantage Canada in future? Sorry, could I start that question again? Okay. Would you agree that disclosure of information relating to current treaty negotiation approaches and strategies, as well as possible shifts in these approaches and strategies, would disadvantage Canada in future negotiations by making it more difficult, expensive, and time-consuming to conclude treaties?
I think it's a very general question. I think a significant part of the treaty process that we engage in here at the operational level with the Department of Aboriginal Affairs is very much a sharing of information on both sides. So I would find it difficult to agree with the principle that sharing of information would create problems, because I think, in fact, it's a key part of the negotiations. As I said, with respect to what Canada wishes to negotiate and on fish, that's merely a matter of following the mandate and instructions that were given.
Would you agree that treaty negotiations would be more difficult, expensive, and time-consuming if Canada's bottom line were made public going into these negotiations?
I think that my personal views on this are irrelevant, and I revert to my previous answer.
Okay. Ms. Dansereau, could you give a DFO perspective on this question? I could read it to you again if you'd like.
No, that's fine. They're very difficult questions to answer, as you can imagine. I think just in basic rules of negotiation, bottom lines are never exposed at the start of a negotiation. They are arrived at through back and forth. And so to state something at the outset is not necessarily useful to the overall process.
Okay, so your evidence would be that it would not be useful to the process?
Yes, that's right.
Okay. Would you agree that the disclosure, actually, pardon me, I'll take a step back. You're familiar with the documents related to the Coastwide Framework or Aboriginal Fisheries Framework to some extent? Are you not?
I'm familiar with some. I am not sure of the entire list that you're talking about.
That's fine. Would you agree that disclosure of Coastwide Framework documents would be harmful to Canada's relationship and negotiations with the parties with whom Canada is in active treaty negotiations, such as the province of British Columbia and the First Nations that Canada is actively negotiating with?
I'm going to object again, and I'm going to object to this entire line of questioning. I'll put it on the record that I'm objecting to the questions that have been answered and the questions yet to come, assuming they're roughly the same, and this particular question. Mr. Ralston says he's not relitigating the motion that you've ruled on, but that's exactly what he's doing.
Mr. Commissioner.
And he's getting into privileged areas.
Mr. Commissioner, I have a similar concern. The suggestion I made is that he put propositions that are relevant to your mandate, but the questions here seem to go straight to the heart of the matters that were before you on the Heiltsuk Tribal Council's application and the ruling that you've made, and don't, at least on their faces, as near as I can tell, aren't designed to assist you in fulfilling your mandate in the context of your terms of reference for the main body of the inquiry.
Mr. Commissioner, Boris Tyser for the province of BC, and we take the same position on this issue as Canada and the Commission Council.
I'm prepared to move on.
I think you should, Mr. Olson.
Okay. I'm going to put some more propositions to you without respect to Ms. Murdoch's affidavit, but I want to see if I can get any agreement to these propositions. And if I run awry of objections, that's fine. Okay. Would you agree that the disclosure of... Actually, no, I'm going to move on. Yeah, I'll move on. Okay. Mr. Lund, could you please bring up Exhibit 596? First of all, Ms. Dunsborough, could you tell me, are you familiar with this document?
No, I'm not.
Okay. Ms. Farlinger, are you familiar with this document?
I may have seen it, but I don't recognize it on first blush.
Okay. Mr. Bevan?
I'm aware of the fact that we have documents of this on this subject, but I can't say that I have seen this particular document.
Okay, thank you. So the document has a date of June 2006 on the cover page. Would any of you be aware of any more recent reiteration of the best practices for consultations guideline for DFO? So documents such as this that would be more recent.
I'm not aware of more recent documents, but I do know there certainly has been more recent activity in terms of sharing and putting out best practices for use within the federal government more broadly, recent guidance from the Department of Justice, and also within DFO. It's something we're actively engaged in at this point.
Okay, thank you. Mr. Lund, could you bring up page 3 of this document? Now, the first paragraph under the heading, The Importance of Consultation with First Nations, sets out several of the reasons why the federal government consults with Aboriginal people. These reasons include to meet legal requirements, to develop and/or strengthen mutually respectful relationships with Aboriginal people, and to fulfill policy commitments and improve policy development. It also states that First Nations can provide new approaches from their cultural perspective, identify pitfalls or gaps in DFO's thinking, and raise issues that DFO has not considered. Is it still DFO's view that consultation takes place for these reasons? Oh, sorry, are we at page 3 of the document? I see page 2 at the bottom. It's not of the PDF. Thank you. Oh, sorry. Would you like me to repeat that question then? Okay. The first paragraph under the heading, The Importance of Consultation with First Nations, sets out several of the reasons why the federal government consults with Aboriginal people. These include to meet legal requirements, to develop and strengthen mutually respectful relationships with Aboriginal people, to fulfill policy commitments and improve policy development. And it also states that First Nations can provide new approaches from their cultural perspective, identify pitfalls or gaps in DFO's thinking, and raise issues that DFO has not considered. Now, is it still DFO's view that consultation takes place for these reasons? Ms. Dansero?
I would say yes. There may be more, but this is a good cross-section of them.
Okay. Ms. Farlinger, would you agree as well?
In the same sense, this seems a reasonable statement that may not be exhaustive.
Okay, thank you. Now, the first line of the final paragraph on this page states that at the heart of consultation is a commitment to constructive and mutually respectful relationships with First Nations based on reconciliation, enhanced collaboration, effective working partnerships, and mutual respect. Now, would you say, Ms. Farlinger, is this still an accurate reflection of DFO's views on consultation?
I think this sentence describes a reasonable approach to consultation, yes.
And Ms. Dansero, what were your views on that? Would this still be DFO's perspective?
It would certainly be part of the perspective, yes.
Okay, thank you. Now, the second line of this paragraph, which goes on to the next page, states that DFO strives to involve First Nations in the early stages of policy, project, and program development, where policies, projects, and programs may affect the interests of First Nations. Consultation allows for an open forum of information exchange, assists DFO in addressing the concerns and interests of First Nations, and generally results in better policies, projects, and programs. Now, would this still be an accurate reflection of DFO's views on where consultation should take place and why?
I would say yes, but we have to keep in mind that, and I'm sure you know this, that there are different definitions of what constitutes consultation, and so what we may consider to be adequate may not be, for all of these reasons, others might say was insufficient.
Mm-hmm. But you would still say that it's an accurate reflection of DFO's view?
Yes.
Thank you. And Ms. Farlinger, would you echo that response, or?
Yes.
Okay, thank you. Now, Mr. Lunn, could you please turn to page 5 of this document? Okay. The chart refers to DFO issues that might require consultation with First Nations. Now, Ms. Dansereau, do you see the line I'm referring to? The title? Sorry. What DFO issues might require consultation with FNS?
Yes.
Which I take to mean First Nations.
Yes.
Okay. My next questions will focus on these listed items of when DFO might need to consult to better understand DFO's perspective on the limitations of their duty to consult. The first item under this list is agreements under the Aboriginal Fisheries Strategy, the AFS, and under the Aboriginal Aquatic Resources and Ocean Management Program, ARAM. Do you agree that DFO might need to consult on AFS and ARAM agreements?
First
The way the question's phrased is calling for a legal conclusion.
I think the use of the word duty to consult is the one that I would have objected to. So these are areas that certainly we would be exchanging information with the First Nations on and consulting on, but I would not put them under the rubric of duty to consult.
Could you clarify the circumstances in which DFO would not feel it necessary to consult on these agreements?
Calls for a legal conclusion.
All right, that's fine. When would you not have discussions on such programs as the Aboriginal Fisheries Strategy or the aquaculture, the ARAM program? So getting away from the duty to consult, in what circumstances would you find it unnecessary to have discussions with First Nations?
We depend on the matter and the situation, and we consult on that, and we seek advice from Department of Justice on that, and we do that on a situational basis.
Okay, I'm going to move to the fourth item in this chart, which is Integrated Fisheries Management Plans, IFMPs. Maybe again, Ms. Farlinger, could you speak to any circumstances in which DFO would not think it necessary to engage in discussions with First Nations on an IFMP? Perhaps particular sections of an IFMP where that would not be necessary? Sorry, I can break that into two questions.
Yeah, if I might suggest, it's the word necessary that's causing problems. My friend
Okay.
asks about practice as opposed to duty.
Really, what the witnesses are here to do is answer a question like, when do you consult, when do you not consult?
Okay, so from DFO's perspective, when do you not consult on an IFMP? In what circumstances?
It is our intention to consult with First Nations on all IFMPs, and I can't think of a particular aspect of an IFMP that we don't consult on. We gather perspectives and interests and views on fishing and requirements for FSC fisheries in our consultation with First Nations. There are stages of decision making that those consultations inform. And once again, I would just go back to a specific issue. The integrated fisheries management plans in their entirety are made available to First Nations, and arrangements are made to consult on those plans. So I'm sorry, I don't think I can answer your question.
Ms. Dansereau, would you have anything to add?
No.
Okay. I'm going to go to the fifth item in this list, which is in-season fishing decisions. Now, again, Ms. Farlinger, could you tell me when DFO would not engage in discussions with First Nations on in-season fishing decisions?
I think that the commitments we make in our agreements with First Nations very clearly indicate that our intention is to consult with First Nations and sets out exceptions when decisions need to be made on a timely way by the minister, but it's a very general distinction.
Okay. Now, finally, I'm going to move to the 11th item in this list, or the second last if you prefer. It refers to salmon enhancement initiatives such as ESSR opportunities and community economic development projects and programs. Could you tell us when DFO would not engage in discussions with First Nations on applications for programs such as these?
I think where it's once again very difficult to define and is situation specific. I think where there is no First Nations involvement and First Nations impact on matters concerning a specific hatchery, for example, who we hire as a hatchery manager, we may or may not ask First Nations to participate in that or discuss it with them.
Okay, thank you. Ms. Dunsborough, did you have anything to add?
No.
Okay, thank you. Mr. Lund, could you please turn to page 8 of this document? The second last paragraph, under the heading Limited Impact, it states that if DFO's view is that the claim to the Aboriginal right or Aboriginal title by the First Nation is weak or limited, or the potential for the proposed DFO action or decision to adversely affect the claimed right or title is minor, the only legal duty on DFO may be to give notice, disclose information, and discuss any issues raised in response to this notice. Is this still an approach that DFO adopts for what it views as limited impacts on Aboriginal rights or Aboriginal title?
This is getting into the area of duty to consult as opposed to consultation in general, and what we have been answering to for the past few questions has been on the relationship and consultation that we have on an ongoing basis, irrespective of the question of duty to consult, and this is much more related to the legal definition of duty to consult.
Well, I don't want information on when DFO would make the decision that there is a duty to consult or that there would be a limited impact in these circumstances. I guess my question, as I see it, is more aimed towards the procedure for what approach would be taken by DFO once they understand that someone, somewhere along the line, has made that determination, the legal determination that there's a limited impact. Would DFO's policy approach be to, where is it again here? To give notice, disclose information, and discuss any issues raised in response to the notice?
It depends entirely on the situation.
Under the heading Medium to High Impact, it states that in all other circumstances, referencing the past 2 paragraphs, DFO staff should consider following the proposed 6-step process described in this document. Now, Ms. Dansereau, are you familiar with the 6-step process referred to in this paragraph?
No, and I don't have this document, so I can't tell where the other subheadings would have been to describe what this section of the paper is.
Okay, could we scroll up, please, Mr. Lund? Okay, so no impact is the first heading that would be referred to. If you'd like, you could take a moment to read that.
Do we have this document here so we can actually look at it?
It should be in my list of documents.
I wonder if my friend has a tab number.
Okay, we have an exhibit number, but not a tab number at this moment. I can move on so as not to waste my remaining time. Okay, I'm just going to go to page 9 of this document. Mr. Lund, if you please. Okay, step 1 here at the bottom of this page is stated as inform First Nations of intent to consult. The first bullet here states that it is important to provide sufficient information so that the First Nation can then decide whether or not to participate in the consultation process. Would you agree, Ms. Dansereau, that this is an important step to go through in consultation with First Nations?
Again, this is a document from 2006. I'm still not clear on whether or not we're talking about the legal duty to consult or whether or not we're talking about consultation in the course of our regular business. So there are formal steps that need to be taken, and they're different in either circumstance, and sometimes it's not as formal as this, and sometimes this is what's required. So I can't really answer your question in generalities because it will be case specific.
Mm-hmm. Speaking practically rather than in the context of the duty to consult, would DFO typically take an approach where the first step that they would go through in a... Okay, sorry, Mitch.
I think the difficulty is that with this question, the witnesses have repeatedly said what they do depends on the circumstances in answer to many of these questions. And now Mr. Ralston is asking typically what would they do. I think it's a difficult question for the witnesses. And and I'm objecting to it on the basis that if they've said it depends on the circumstances, how can they answer a question typically, what would you do? This document, as I understand it, is an exhibit that went in at some point in time. I may have been present in the hearing room when it did, I don't recall it. I suspect it went in the Aboriginal panel hearings. We haven't been given the context that this document went in under and what it was identified as. I can see from the beginning that it's best practices, it's a fisheries and oceans document, and it says that it's a practice document, and page 2 refers to it's not policy, it's some guidelines. And essentially, as I understand this document, it's a example of transparency where what's being said to DFO staff is being put on the website and otherwise given out so people know the approach. But it's a practice document that's then applied by staff in particular circumstances in their daily work.
Okay, this document was adopted, my co-counsel advises me, in the testimony of Mr. Huber as well as Mr. Rosenberger earlier in these proceedings. Now, I don't have that citation before me, but I could pass that on to the Commissioner if he so wishes.
The document, Mr. Commissioner, was originally entered, I believe, on March 16th. It may have been Mr. Ryle, although we're trying to sort out exactly who it went in through. I don't see it listed on my friend's list of documents, and we've been attempting to find a full copy of it so that Ms. Dansero can view it. I don't know if it's in the binders they have before them because I don't see it on the list here. There's 80 odd exhibits and I've just done a quick scan. But if it's just an exhibit and not on one of the lists, we don't have the ability at this moment to put a full version before the witness.
Okay, my co-counsel's reviewing our list of documents, but I'm prepared to move on to another stage of questions.
If I may also, I really am not trying to be difficult here. It's just that there are various ways that a consultation could take place. A meeting could happen between myself and a chief, and we could decide that we need to consult further on a different issue. A meeting could happen between the minister and some chiefs and decide that further consultation is required, and therefore certain steps would flow from that meeting. So if this is a general practice that happens in the field for standard, possibly it is. I don't know, but I do know that I can't say under oath or under affirmation or whatever that this is always the way. There are different types of approaches depending on the circumstances.
Would you agree that there's always some amount of sharing of information and exchange of information then during a consultation process between DFO and First Nations?
Yes.
Okay. Just give me one more moment then. Okay, and would you also agree that DFO generally engages in some amount of response to First Nations, which would essentially deal with the concerns raised during the consultative process that those First Nations have raised?
Yes.
Okay. Could you explain why that would be important for DFO to give that response?
To exchange information? If
No,
we're
sorry,
consulting, we are
response.
exchanging
Yeah.
information.
Yes. So, okay, I can say the information exchange. Sorry, I've been thrown around a bit here. Okay, so information exchange, you do agree that that always takes place, as far as you know, during DFO's consultation process?
Well, usually because the point of consultation is to exchange information.
Okay, usually takes place. Would you agree that it's important that this takes place?
Yes.
Okay, would you agree that in circumstances where information is not being exchanged, it ought to be exchanged during a consultation process? Okay, that's fine. Okay, in terms of a response from DFO to First Nations addressing their concerns at a later stage in the consultation process, would you agree that that's generally an approach that's adopted by DFO?
I guess I'm a little bit worried that you're going to go down a road that says in all cases we have to give all information. Clearly, if we're in a negotiations, which is different from a consultation, there will be some information that will not be shared at the outset. As we said earlier, when we're in negotiations, we don't disclose all information at the outset. So there are various types of engagements that we have with First Nations, and all of them require different levels and degrees of information sharing.
Thank you. I'll leave that point, but I was actually trying to speak to the DFO's response to First Nations. So a later stage in the consultation process whereby DFO would address in as much detail as appropriate First Nations' interests and concerns which have or have not been addressed by DFO during that process. Would you agree that that is something that generally takes place, a sort of follow-up on behalf of DFO.
Well, I've got the same objection, really.
I'm willing to move on. Okay, I'll withdraw my last question for the record. Thank you. Okay, I'm going to move on to one more line of questioning. Okay, I have 5 minutes remaining, so I'll see what I can do. Now, we understand that DFO manages to an endpoint allocation percentage for Aboriginal access to salmon. And we're respectful of the fact that we are not at liberty to ask you for that percentage figure. Now, being mindful of the Commissioner's September 20th ruling on the Coastwide Framework Document Disclosure Application, the letter of Mr. Wooters, dated September 22nd, setting out Cabinet confidence claims over the documents ordered to be produced, and the objections heard this morning, I'll be keeping my questions general and, as much as possible, trying to avoid asking for any particular contents of any particular document. I would, however, like to ask some general questions about how an endpoint percentage is contemplated.
I'll object to the entire line of questioning before we start, and I'll further object as we go.
First of all, could you confirm that the endpoint percentage covers both FSC and economic access for First Nations?
I object.
Objection sustained. Objection sustained.
Okay. When modeling for an endpoint, has DFO explored the possibility of increases in economic access opportunities to levels that would require a concomitant decrease in current FSC allocations to remain within the endpoint percentage?
The Section 39 certificate is extremely clear that if there is to be questioning and oral evidence on the endpoint, the Section 39 certificate is saying that too is a Cabinet confidence.
Okay. In our submission, our understanding of Mr. Wooters' letter is that questions for oral testimony to the actual percentage set out in these documents over which Cabinet confidence has been claimed, that is the information that will be objected to in terms of oral evidence, as opposed to more of the process behind the actual existence of an endpoint allocation. Okay, testimony has already been given in this commission on some of the modeling that's taken place under a endpoint allocation for First Nations access under this coastwide framework. And I can bring the Commissioner's attention to the testimony that has been given, if he so wishes. For example, on August 19th, if Mr. Lund could please bring up that transcript. At line 25 of page 38 of this transcript, Mr. McGowan has a line of questioning towards how DFO can model under one endpoint percentage allocation. I'll just wait for Mr. Lund to bring. Okay. All right. And likewise, in September 2nd, I'll just get this on the record, of 2011, at page 89, line 8 of that transcript, Ms. Fong begins a line of questioning, asking various questions on the endpoint allocation percentage as to how this endpoint allocation affects particular Aboriginal programs, such as PICFI and the AFS agreement, and testimony was given on that topic. Our understanding is that in those circumstances, pursuant to the Supreme Court of Canada case of Babcock in Canada, wherein the Supreme Court of Canada stated that a claim of Cabinet confidence does not apply to information that has already been disclosed. And now I can hand up a copy of this ruling if the Commissioner so wishes, and we have copies to distribute to other participants. But pursuant to that decision, we would make the submission that over certain aspects of information here, Cabinet confidence has been waived and cannot be claimed.
Well, if the question were, I'm putting to you what Ms. McGivney had to say, which is the witness he's speaking of, what do you say about it? Fine, but I didn't understand that to be the question. He seems to be wanting to go behind the end point.
Okay, if I can respond. We have no interest in seeking what's already had Cabinet confidence claimed over it, which would be the endpoint percentage. We simply want to understand how DFO will be dealing with the fact of an undisclosed amount, but that is a percentage. And we wish to simply ask questions based on that process for how they will model underneath a fixed percentage, whatever that fixed percentage may be, and and move forward on that ground.
I think you're probably going to run out of time before we get to more submissions, but following Mr. Taylor's suggestion, if there's evidence already before the commission, Mr. Ralston, and you mentioned, I think, 2 transcript references, if you wish to put those transcript references to these witnesses to get their view on that evidence, I think that's appropriate.
Okay.
If you wish to do that.
Okay, I'm just going to move on. And Mr. Lund, could you please bring up Heltzig Tribal Council's document number 76? Okay, this is a document related to the question that I'm asking, and it will be my last question. Mr. Lund, could you please move to page 3 of this document, and could you focus in on lines 10 to 14 of column B? Now, line 4 reads, FSC allocation decreased by 100,000 pieces from historical, whereas line 5 reads, First Nations communal share of the commercial CTAC is doubled to 40%, non-First Nations share is 60% as of 2008. And my question for you, Ms. Dansereau, would be, although very little context is given in this document, would you agree that it appears to involve modeling of a scenario in which FSC allocations of Fraser River sockeye salmon are being decreased, whereas communal access to commercial allocation is being increased?
I'm sorry, I have no idea what this document is or what it is trying to say.
Ms. Farlinger, I could repeat the same question. Could you speak to this? Are you familiar with this document? It was on our list of documents, and it was disclosed to the witnesses. And
I'm not entirely sure of what the context is. I do know that when models were run, and I would just refer back to the comments from Dr. Richards on modeling, a variety of assumptions are tested and made. These may form some of those or not, I'm not sure.
Mr. Bevan, could you add any further information on this document?
Well, the models were run to create the aggregate number, and I'm loath to comment further than that on these as it relates to the discussion that's being held prior to getting to this particular document. I can't put this in a particular context, but I do know that we're looking at scenarios depending on the circumstances in a particular First Nation, if they had an economic opportunity, fisheries, etc. But it gets to part of the coast-wide process.
Okay. Could I have this document marked as the next exhibit, please?
Well, no one's identified it as anything. I'm wondering if this is part of what is properly privileged. I frankly don't know what this is. It's seemingly gone in as a unidentified document. I think the most that it could be is a document for ID.
Could we just simply zoom in on the information at the bottom of this document? Now, this is, in our understanding, a DFO document. It was disclosed through the ringtail procedure, and it is a document that we disclosed on our list of documents well within our week's notice to Canada and other participants. And it's something that we would also imagine under commission processes would have been put to the witnesses. Okay, so our understanding is, well, it refers to a ROB. There's definitely not a particular author we can refer to here, but we do understand it to be a document that has been disclosed by Canada and is ostensibly a DFO document. And it contains what seem to be ostensibly models of a scenario in which FSC allocations are decreased so that economic opportunity can be increased.
Mr. Commissioner, just perhaps by way of assistance, I know we're well over Mr. Ralston's time now, but perhaps to clean up this last, I don't know if any of the witnesses or Mr. Taylor can exist, but there's the initials PAFF near the bottom of the page, and if my recollection serves me, that has some association with the coast-wide framework process and may well fall within the context of your ruling in the event this document was inadvertently disclosed. I don't know if that might assist Mr. Taylor.
Mr. Wilson, may I respectfully suggest that we mark this for ID purposes? Perhaps Mr. Taylor, yourself, and Mr. McGowan can further discuss its source, and I could be advised later as to some clarification on where this document comes from and whether or not there, as Mr. McGowan says, happens to be an element of it that might fall within the privilege communication category. But at this stage, perhaps the safest thing to do is mark it for identification purposes.
Okay, thank you.
Thank you.
Those are my questions.
It'll be marked as 00000.
Brief afternoon adjournment, Mr. Commissioner.
Yeah, can you just tell me what's left on the agenda, Mr. McGowan?
Yes, Mr. Commissioner, there is a couple of housekeeping matters which will need to be addressed. Mr. Taylor, I understand, will have some questions in re-examination. I will have some questions in re-examination. And certainly if you, Mr. Commissioner, have any questions, there will be time provided for that.
I just want to make sure we don't run out of time before 4 o'clock, just to...
I understand we're concluding at 4 p.m. today.
All right, thank you.
Okay, we now recess for 10 minutes.